so kind, take a seat right over there. Thank you.
Well, why I'm sitting down for, sir?
Right over there with Mr.
I'm saying, why am I sitting down? I'm asking questions. And I put in motions. I gave you petition for release.
All those motions I've reviewed, they are denied.
You not for to sit up here and tell me that you're gonna tell me you're gonna violate my motherfucking rights. I don't give a fuck about that. I don't give a fuck about that.
For your vote.
Well, that escalated quickly. But wait, there's more. This is Mr. Harper. He's an angry man. This guy made the rounds yesterday on Law Talk with Mike and OldSquishy, but this video has context. I've included his previous hearing from March. Spoiler alert, he's every bit as angry, loud, and stupid as he was yesterday. In true Pulp Fiction style, I'll begin with yesterday, then show you some of the March hearing, and then bring you back to yesterday. You're gonna wonder why they didn't take their own advice. Let's roll, nerds.
The defendant is Desmond LeRae Harper, and then there's a new case or two.
Bring your eyes.
Three new cases? Three new cases and two motions to revoke probation, correct?
That's correct.
All right. The defendant is guilty. Bring the defendant in, please. Thank you. Hey, Mr. Harper, if you'd be so kind, take a seat right over there. Thank you.
Well, why I'm sitting down for, sir?
Right over there with Mr.
I'm saying, why am I sitting down? I'm asking a question.
You don't want to sit down?
No, it ain't. That's not what I'm asking. I put in motions. I gave you petition for release.
Yes, sir.
Because of delay.
Yes, sir.
I'm still doing. I did a speed trial with case law.
All those motions I've reviewed, they are denied.
You can't
We're ready
deny
for
it, sir.
Yes, we can. Sir.
No, you can't. They got to go to Austin.
No,
And no. With case
these
law.
hearings.
With case law.
That would
case
be
law. No, you not for to sit up here and tell me that you're gonna tell me you're gonna violate my motherfucking rights, nigga. I don't give a fuck about that. I don't give a fuck about that. I don't care about that. I give a fuck about you, none of y'all. Fuck y'all. Fuck is you talking about? This is my motherfucking life, white boy, you Egyptian pharaoh. Cause this law right here tell you federal congressional enactments authorizing or empowering any of the defendants named here to the place detained on parole for no apparent reason at all to cause plaintiff to be detained on the pretext that he might be convicted.
Let's get Mr. Harper. He's on probation for two cases, and there's three others, right, that are new? Two cases are called 23 CR.
Not far.
23 CR.
Over there, I see you. I see you. He's fired.
Doesn't matter. You're going to sit there for this hearing.
I see for no hearing if I don't want the lawyer.
You can do it, Judge.
I'm firing him.
You're ordered to sit next to your lawyer.
I'm firing him. He's fired.
All right.
A lawsuit on everything.
All right, you sit there and
Not
represent
doing no
yourself.
hearing with y'all. With his lawyer.
Represent yourself.
No, I'm not. I got a right to have a lawyer.
But not when you can.
Man, you got me, man. I'm getting a lawyer, man. You can't tell me. You can't tell me.
Yes, I
you
can.
ain't bigger than the law.
Yes, I can.
Okay, man. No, you
You're
can't.
held in custody. You are held in
You got
custody.
me on my.
Now you are
Talking about.
180 days in the county jail for your vulgarity, for your obstinance, and for your disregard for all law and proper behavior.
And Your Honor, this happened last time. And
We're
I think
gonna next time we're gonna bring him out. We're gonna have him gagged.
well, it's very difficult for us to get the witness here. He's repeatedly, you ordered him last time not to contact her after he tried to get her not to prosecute. And he has been contacting her over 109 times we
need to put all that on the record, but what we'll do is we'll put him in a cubicle or something where we got to figure out how to do that, where he's separated and he is gagged so that he cannot make outbursts. We got to figure out a way to do that.
I think what Mr. Boyd's asking is that we take some of those measures today. Because
You will find. How do you propose we do that?
Well,
You got a plan?
It's going to be possible from the sheriff's office.
I defer to you. I was somewhere.
As far as at the jail and not being able to.
Judge, you don't like it when somebody's
Prohibit the further communication.
Right. How are we going to keep him from, because he's still been contacting her right through different accounts.
Correct. He's been using other inmates' phone accounts And when I finally contacted the control room officers in maximum security, told them to turn the phone off when he's in the day room. He then has the inmate in the adjoining day room make a phone call and just speak back and forth, relay information.
Okay. Well, we've got, he is combative, and he's not going to follow. It's obvious he's invoked his statements that were clear that he isn't going to be peaceful in any way. So we've got to fix a presentation to where he is separated from harm to others, but he is present in the hearing. And I think what we can do is just do it from the jail, I think, and do it by video.
Judge, we asked the jail if that's something that we could do, and they said no.
And Your Honor, I believe you had suggested last time that Mr. Matuska maybe do it via Zoom and the defendant be in court. I think that was it.
Well, you can see what he does in court.
Yes, and
So what do we do?
I'm just letting the.
What do we do? I mean, he's
Is there a means in which he can hear but still be contained? We really need to get this testimony.
okay, but we've got to have civility, and the outburst, we've got to control him. He is combative. I'm open to whatever everybody agrees that can be done to hasten this along, because the way it is, I mean, he can just have an outburst like a child and outshout everybody, and then the rules don't apply to him. But I want him jacketed. I want him in a jacket, and I want him gagged if I have to, and then he will take his gag off, but he can listen. He has a right to listen, but I want him restrained and gagged. And when he has a chance to be heard, we'll hear what he has to say, and then we'll gag him back when they're through. So he doesn't control the proceedings. If anybody has another idea, let me know.
Possibly, another attorney might be something that comes.
How could we possibly, what have you thought you've done that would cause him to be angry with you?
I'm only listening
what?
to what he's voicing for either representing himself or having another attorney. I seem to aggravate.
No, they don't get to pick attorneys.
Yes,
He can hire somebody, but he can't pick one. And you're a competent lawyer. That's what I find. It's and we open the door for one. We open the door for everybody. If they just want to change lawyers, there's theoretically no end to it. If there isn't a rule that's based upon good cause, and he doesn't show it. He hasn't stated any good cause. And I know you to be a fine lawyer. So, well, what do you suggest we do? How do we practically do this in this courtroom? I don't have a bulletproof, transparent cubicle.
He's not objecting to the proceeding. He's objecting to representing himself and having me as his lawyer. That's all I heard.
That is true. I heard the same.
Are you saying if you disappear, he'll be okay?
I'm only saying this.
No. Is that what you're saying? If I said go, you can represent yourself, sir. You think he's going to be fine?
No, he wants to voice himself. He wants a voice. Clearly, he wants to defend himself. I'm just saying simply that he came in here just a minute ago and he said he wanted to represent himself and he did not want to be involved. He did not say he did not want to be a part of the proceeding. That's all I'm saying.
All right, bring him out again. Come on up, sir. Here's what I'm going to do, Mr. Harper. He's fired. Is that
Okay.
that's good? Okay. Are you going to represent yourself,
I'm pretty much probably gonna hire an attorney.
sir?
Probably gonna hire an attorney.
Are you able to hire
I
somebody?
am able to hire some.
Who is there? Anybody in particular you wanted to talk to?
Probably gonna be out the
Do
city.
you have any names or anything?
No, out the city limits, but
How long would it take you to hire someone?
I need a little time with it. Like,
A week?
need longer than
A
that.
few days?
3 months.
No, I can't give you that much time, sir. Is there any names you have that you would like?
No,
we might be able to call them and ask them to.
I don't want nobody in this county. I don't want nobody in Jefferson County. I don't want nobody in the confines of Jefferson County. I don't want nobody out here, period.
How long have you been in jail on this thing?
Like 15 months. So.
It's too long. Do you have any thoughts of any names that come to mind that you would?
Well, I don't have no thoughts of name, but I got some ideas. And
Like what?
I got like some people I can probably,
Like who? So
talk
we
to
can.
that give me like numbers or names
you
and stuff
need
like
some
that.
tips from
I
somebody.
got tips from people, basically. I'm trying to get somebody from out of town now.
All right. How long would that? I can't give you much time. I'll give you a week to figure that out, and then we'll bring you back and see what happens.
About a month or something.
See where you are in a week.
But
Okay.
to be honest with you, sir, I ain't gonna lie to you. My rights been violated, so I have put in a change of venue. I never heard nothing. I did habeas corpus, 2 of them. I heard from one, haven't heard from the other. I'm actually filing another lawsuit too because I wasn't able to get on the kiosk at all at one point, and for the grounds of me being segregated, I haven't been through a due process of law or nothing to be put in segregation or be on any restrictions. I wasn't able to do grievance, law library.
Hold on.
I wasn't able to do none of this. I haven't been able to use a phone for 7 months. Call my family. I got 2 sons in jail.
Do you know
God's son and my real son.
Hold on. Do you know what you're charged with on all this so you can focus on fighting those allegations? Do you know what you're charged with? It says 1, you violated probation by committing aggravated assault with a deadly weapon. This all looks like it's on or about the same date, November 21st. All of this is all about November 21st, 2023. That's all. This is what everything.
I'm ready to go to trial for that right now.
Yeah.
We can go to trial for that right now. Let's go. So
this is a motion to revoke that goes before the trial.
I got a case law to tell you. You can't do that neither.
Okay.
I can pull this out and show you.
All right.
I can read it to you and tell you case law.
But you want to go forward with the motion? That's what we can do today.
No, I'm telling you.
When can you get ready for that?
We ain't supposed to go forward with a motion when the paperwork tells you and the law states that. You see?
Your Honor, Mr. Harper, he's on there with his mother admitting that he's using all these different accounts, using different individuals' accounts, even though you ordered him not to communicate with anyone on there.
So
he's on there.
Let him do that.
I'm
gonna keep doing it. I'm gonna keep doing it, bro. I'm gonna keep doing it. No state shall deprive any person of life, liberty, or property without due process of law. U.S. Constitution. Come on now, what are you talking about?
Don't interrupt people, please.
Yeah, what he interrupted me for? Interrupted me.
Sir, please follow the rule. Thank you. Are you representing?
No, representing myself. I'm telling you what you wrong at. Look,
all right, and it's noted, and you'll get to appeal that. You've made a point, you'll appeal. We're going to still move forward with the motion to revoke probation.
I'm not going forward with a motion to revoke.
You don't have a choice, sir.
I do have a choice.
Yes,
I'm not going to go forward with a motion.
It's a court order.
We're going to move. It's not a court. I don't understand about your violation of my rights.
You don't care about the
court
Constitution.
order.
You don't care about the Constitution in your.
Give a fuck about the Constitution.
You were so
obnoxious, out of here, man.
And that's when Judge Stevens muted the proceedings. Harper's let out again, and the court has a lengthy discussion about what to do next. Keep in mind, we're still in March, and they're deciding what to do with him the next time they have to bring him out, which was yesterday.
Motions to revoke unadjudicated probation have been filed. By the way, he was placed on probation on August 21st, 2023 in this court. And it is alleged that the defendant, Desmond LeRae Harper, has violated his probations as of motions to revoke probations filed on January 5th, 2024. It is alleged that in each case, he committed the offense of aggravated assault with a deadly weapon. The defendant was brought in today for a motion to revoke probation, and needless to say, was violently combative, vulgar, cursing, and abusive to the court, everybody here, and also to his attorney, who he stated he fired and did not want his attorney at all near him. And we are going to move forward on this motion, these motions to revoke probation. It's obvious we've said enough to him. When he is not getting his way, he screams and shouts vulgarities and is uncontrollable. First thing, the court is going to order that when he's here, he shall be gagged. The tail does not wag the dog. We got to have control in here. And that's, if somebody can come up with another idea, let me know. But we've done this I've been a lawyer for 40 some odd years. And in federal court, we were able to bring in cubicles, but we don't have this available here. And he has a right to be present, but he doesn't have a right to control and put the proceedings in disarray and make a mockery of it. So we can, and needs to be, there's not a jury here. He can be restrained. He needs to be restrained as well because he's a violent man. But he's going to be ordered in this courtroom to be restrained and gagged. Also, he is ordered not to have any phone contact from the jail. And I don't know how that's happening, how that's going to get controlled, but it needs to be controlled. He is getting in contact with complainants and witnesses. And the state says they can't control it. The executive branch needs to do that, or else I'm going to find out why that can't be controlled. He obviously has a plan by his actions he won't like. And so he can be disruptive and there's no end to this. We've got to control the proceedings.
And Your Honor, the only way, my understanding, the only way to prevent the defendant from actually communicating with anybody outside is for the court to order him held in isolation.
All right. The court finds just cause by his actions today and his statements made. And what the officers of the court are telling this court that he makes, he's able to have people on his behalf make phone calls, which can intimidate and influence witnesses, which disrupts the very heart of due process and the right to a fair trial, which is given to the state as well as to the defense. That he is now controlling this proceedings, which is not what the Constitution was intended for. It was for responsible people to handle it and make sure that it's accomplished, not giving the keys to the candy store to children who just want to eat candy.
Well, the new offense, then sick he will always be in violation.
You're thinking,
Motherfucker, a parole takes from plaintiff to presumption of innocence and just violates the 14th Amendment. All right, then,
it's be,
I'm not doing none of that.
All right.
So get up out of here, nigga.
you're taking outside.
Bitch ass nigga.
Go back to the
Fuck you,
cell.
Pharaohs. Fuck y'all.
Go back to the cell.
Fuck you, Pharaohs. Yeah, give me about your courtroom, bitch.
Sorry.
Yeah, nigga. What you gonna do, nigga?
Just make sure.
What you gonna do, nigga? Bitch. Yeah.
Make sure that the speaker is on so we can hear. Mr. West, you made sure we took care of competency matters earlier, didn't we?
Your Honor, I was just appointed on this case like 2 days ago. So,
Do you know anything about this?
and I've got to discover from me and Mr. Boyd to talk. I know about the facts of the case. I know about the details. I spoke to my client a little bit. I know that at one point he was evaluated for competency and was found to be competent at one point. But I mean,
Well, there's a competency evaluation back in December. And we did that because the similar actions that he displayed here in vulgarity, obstinance, anger, and raving lunacy type statements are similar to what we caused Dr. Ed Rapon, licensed psychiatrist, to evaluate the defendant, who submitted a report December 9th, 2024, that states that the defendant is competent to proceed to a resolution of his legal issues. is there any reason why you feel like we need another report at this time?
Your Honor, due to the fact that he is very uncooperative and not willing to work with us, even when I was talking to him, he's not wanting to move forward with doing anything. He's just ranting. I would argue, I know Dr. Pons found that he's competent, but I would suggest that he's incompetent due to the fact that he is unable to assist his counsel in moving forward with this trial.
Yeah.
Or this hearing and or these trials coming up. So I would request to have it evaluated again. But I'll leave that to the court. The court's had more experience with them than I have. I've just only been on the case 2 days, so I don't have months of experience like y'all have with.
And Your Honor, this is his third or fourth attorney. This is.
It doesn't have anything to do with Mr. West. I understand that.
Your Honor, I just meant, I think it's its way of stalling and keeping this case. He, in the underlying case that he was placed on probation for, he contacted the witness, tried to keep her from testifying. That's why he was given a deferred, because we couldn't get her. He's done the same thing in this case, contacted her from the jail. There's nothing on those jail calls that suggests that he's incompetent in any way. He carries on normal conversations with his mother. He doesn't get his way, and he comes in here and thinks he's going to delay the proceedings, which he has several times now, because he knows we have a hard time getting the complaint.
But once again, I would prefer Dr. Rapon, since this was 6 months ago, Dr. Rapon follow up with an evaluation.
Well, when we won't be able to get the complaint, sometime in the future. And
but once again, we could have had a hearing, I guess, earlier, but 6 months have gone by. Mr. Boyd, could you pay attention, please? Would you be so kind? Just don't. I mean, that's just like what I just had to deal with him, turning your back to me.
I was looking at Mr. Larry. See, I don't know what to do. I mean, I don't know what to do on that.
Well, what we want to do is whatever way we handle it, we want it to be a secure decision that is not reversed. I want to make sure that all the I's are dotted and T's are crossed. What is the problem in having another evaluation at this time? I mean, I think Dr. Rapon could make it happen within 48 hours or so, but where do you see a problem?
I guess just my idea is that he acts like this every time, the difficulty in then scheduling
But I know, but how many times have we, at the end of the day, how many times have we had this motion to revoke probation hearing set for a hearing? Is this the third time?
I think it may be the fourth, where he acted out at least 3 times prior to this and first for me. So that's just what I'm concerned with, is that I know we're very busy in here and that it may take, let's say take another 6 months to get to a hearing because of.
Why would it be? Yeah, I mean, if now he's got our attention, again, we know, it's just, do you remember the dates of the other hearings? I'm looking to.
Probably had, if we had an evaluation done in December, I would bet January. And then maybe February, and then March is when we had to have him to solitary. That's not able to speak. He wouldn't be a priority, and I think we would. I tried again with April. And we did today because it was actually
I need to, we need to have dates so she can pick up the record. So I can look at the record real fast. Now, I'm not showing in this when hearings were held or attempted to be. I see where there were some resettings for a particular date, but there's nothing that shows what happened on those dates here.
The other than the one where we get the memo to the jail, that was the.
Well, here's the deal. It is as well is that's the most important thing is what do we do with proceeding with a hearing with him not present in the courtroom? Because his presence in the courtroom is volatile, vulgar, obstinate, angry, and I've remembered this over and over again. So what do we do, Mr. West and Mr. Boyd?
I'm gonna, like I said,
Since they have a right to be heard.
I must keep my position that he needs to be evaluated because he's unable to effectively work with anyone, much less me.
What do you say, Mr. Moore?
Your Honor, the Ninth Court of Appeals had a case very similar to this, in which an individual kept trying to delay the proceedings. Again, there's not a jury here. And I think that was part of the argument. It's not influencing a jury in any way. If that individual is the individual was given 2 or 3 opportunities to come out to behave himself. He did not. He was then placed in a holding cell where he could hear the proceedings, and it continued from that point on. And the court held that was.
How does he confer with his attorney?
If the attorney needs to ask him.
How does he confer with his attorney? Anybody know?
If the attorney needs to ask questions, the attorney can go and stop the proceedings, go back and ask a question of his client. But if you disrupt the court so that you cannot hold the proceedings, otherwise you're voluntarily absenting yourself from the proceedings because you're creating the situation, not the state.
What are the other dates of the hearings? So I can put that on the record.
I have July 31st, 2024, Your Honor.
Okay. Hold on.
Yes, sir.
7/21.
7/31, Your Honor. Yes, sir.
Okay.
And then March 19th, 2025.
Okay.
I think we had him January.
And those are the 2 that hearings were scheduled where we had it. There were 2 times before where there was announcements, but that was in.
During those announcements, I think he was obstreperous.
Yes, Your Honor.
We weren't even on.
Okay.
I want to say that was for January.
Okay. So 7/31 of last year and 3/19 of this year were the 2 hearings for MTRPs?
Yes, Your Honor.
Would you be some kind of? Well, those, let me look, we're going to take a short break. I want to review the transcript on those hearings and make a record of them. We're in short recess.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me, and let me know what you'd like to see and how I can improve. Thanks.